Today, I would like to discuss an important legal development that has received surprisingly little public attention. On June 12, 2026, the implementation phase of the European Union's Migration and Asylum Pact entered into force. Most media coverage focused on asylum procedures, border controls, and migration management. However, buried within these reforms is something that may prove equally important in the long term. For the first time, European law explicitly requires authorities to identify and record indications of statelessness. This may sound like a technical issue. It is not. It touches upon one of the most fundamental questions in law. What happens when a person belongs to no country? And even more importantly, what happens when legal systems recognize the problem but fail to solve it? Today I want to explore this issue through the lens of comparative law. What is statelessness? A stateless person is someone who is not considered a citizen by any state under the operation of its laws. Without citizenship, many rights become difficult to exercise. Obtaining identity documents becomes complicated, traveling becomes complicated, accessing administrative procedures becomes complicated, even proving who you are can become a challenge. Statelessness is often described as an invisible legal problem. Many stateless persons are not immediately recognized as stateless. Instead, they are classified as undocumented, unknown nationality, nationality not established, or simply left in administrative limbo. For decades, this has been one of the greatest weaknesses of European nationality systems. What changed under the EU Pact? The new EU Migration and Asylum Pact introduces a significant change. Authorities are now expected to identify and record indications of statelessness during screening and asylum procedures. This is a major step forward. Why? Because a legal problem cannot be solved if the legal system refuses to acknowledge that it exists. For many years, stateless persons simply disappeared inside administrative categories. The Pact attempts to change that. It moves statelessness from the shadows into the official legal framework of the European Union. But there is a crucial question. Is identification enough? Germany provides an interesting example. In 2024, Germany introduced important reforms to its citizenship law. Residence requirements for naturalization were reduced. Multiple citizenship became more broadly accepted. These changes benefited many immigrants. However, from the perspective of stateless persons, the picture is more complicated. Germany still lacks a dedicated statelessness determination procedure. In practical terms, this means that identifying a stateless person and resolving the consequences of statelessness are often two different things. This creates a contradiction. The law may recognize the existence of statelessness, yet administrative procedures may continue to require documents, certificates, or proofs that stateless persons are uniquely unable to provide. Recognition exists, solutions do not always follow. And this is precisely where many legal disputes continue today. Greece offers a different perspective. Recent migration reforms have modernized several areas of asylum and migration law. The country is also implementing the obligations arising from the EU Pact. However, practical challenges remain. European case law continues to raise concerns regarding detention conditions, procedural safeguards, and access to effective remedies for vulnerable groups. Stateless persons often fall directly into those vulnerable categories. The Greek example reminds us that legislation alone is not enough. Administrative systems must also be capable of implementing the law effectively. A right that exists only on paper is not yet a practical solution. This brings us to the central theme of today's discussion: comparative law. Traditionally, comparative law was often treated as an academic discipline. Lawyers compared different legal systems, professors wrote books, researchers published articles, but modern legal problems are increasingly international. A child may be born in one country, live in another, have parents connected to a third country, and become subject to international conventions interpreted by European courts. No single legal system can fully understand such cases in isolation. Comparative law therefore becomes more than academic research. It becomes a practical tool, a method of identifying solutions that already exist elsewhere. a method of discovering what works, and a method of improving laws that have become trapped by rigid assumptions. Childhood statelessness. Perhaps nowhere is this more important than in cases involving children. European institutions, UNHCR, academic researchers, and civil society organizations continue to warn that childhood statelessness remains a serious problem. Children may spend years without a recognized nationality. Sometimes the legal systems involved are aware of the problem, yet no institution possesses the authority or flexibility required to resolve it. This is where comparative thinking becomes essential. When one legal system reaches a dead end, another may already possess a workable solution. The challenge is creating mechanisms capable of learning from those solutions. The EU Pact represents progress. There is no doubt about that. Europe is becoming better at identifying statelessness. It is becoming better at recording it. It is becoming better at recognizing it. But recognition is not the final goal. The final goal is resolution, citizenship, legal status, identity documents, protection, and ultimately legal certainty. The coming years will determine whether Europe can move beyond identification and toward genuine solutions. The most important lesson from recent European developments is this: statelessness is no longer invisible. The European Union has begun to recognize it. The question now is whether European legal systems are prepared to solve it. In my view, comparative law offers one of the most promising paths forward, not because it compares legal systems, but because it helps us discover solutions where existing systems have failed. Thank you for watching. If you are interested in comparative law, citizenship, statelessness, and legal reform, please subscribe to the channel and follow the ongoing discussion at law-clinic.eu.